There are more and more immigrants arriving in Canada.
Honourable member for Timmins, James Bay.
Thank you, Mr. Speaker. Always a great honour to rise in this place. I'm very honoured to have the opportunity to talk with my friend, the Minister of Crown Resources, Crown and Indigenous Resources. I will keep my remarks fairly short so we can make the most of this. I think of the Prime Minister saying that his most important relationship is with First Nation people. When I talk to First Nation families, they tell me their most important relationship is with their children. And what we're talking about tonight is the policies of this government that have systemically discriminated without caution and been found to be reckless discrimination against children who have died. These have consequences. I think of Azrea Coco Panance Akpi from Grassy Narrows, Amy Owen, Chantel Fox, Jolyn Winter from Wakapika, Kanina Suturtle, Tiana Quiche, who was found in a brutal condition in the McIntyre Riverway, Courtney Scott from Fort Albany, who died a horrific death, Jenna Roundsky. And I think when I read the latest ruling against this government, they said no amount of compensation can ever recover what these children have lost. This case of racial discrimination is one of the worst, and it warrants maximum awards. So I have named a few of the children that I am aware of and whose family I've spoken to. APTN says that while this government was fighting the Human Rights Tribunal, 103 children died in care in Ontario. Can the minister tell us how many children died in care across this country while her government fought the Human Rights Tribunal?
Honourable Minister of Crown and Indigenous Relations.
Mr. Speaker, I thank the member for his ongoing advocacy. Every child that dies in care is one child too many. This is being a national tragedy that is a key part of missing and murdered Indigenous women and girls. It's a key part of really how failed government policies for generations have ended up in this terrible tragedy. Our government has decided with the families to actually do everything we can to not separate families and not have children in care. The legislation in C-92 will mean that communities will have the resources necessary to keep those families together, to get that child to the healthy auntie or the healthy grandparents. They won't have to live on their own, and to bring their children home. It is the children in care in unsafe circumstances in the cities of this country that are leading to this tragedy. This is about all, but also I want to assure the member that we have to compensate the people that were harmed by this failed policy.
Member for Timmins, James Bay.
The question is how many children died while this government fought the Human Rights Tribunal? Thank you.
Sure.
Member opposite knows very well that the numbers that we have had on so many issues, including missing and murdered Indigenous women and girls, are not good numbers. And that whatever number that he would give me, it's probably way higher, and it's got to stop.
The honourable member.
Thank you. Well, I appreciate that from the minister, but the minister's legal brief from her government to the federal government says the opposite. It says, in paragraph 31 in their latest filing, there is insufficient evidence to demonstrate that any particular children were improperly removed from their home. Does the minister agree with her government lawyers?
The honourable minister.
I believe that we know that apprehension of the children, whether it's all of the class actions that we have settled on 60 Scoop, on Days, on all of these things, we know the children are safest when they're with their family or extended family or in their communities. I do believe that we need to find alternate ways to keep these children safe.
Member.
The question was, this minister's government has gone to federal court to quash a ruling that's found them guilty of discrimination, and they said that no evidence was produced that there were harms to children. Is that the government's position? Yes or no?
Minister.
Mr. Speaker, I think that we all know that children apprehended from their families do not do well. Children aging out of care do not do well. That we actually need to keep these families together. That has been the focus, as opposed to the money going to lawyers to apprehend children, agencies, and non-Indigenous foster families. We need these children supported at home in their community.
The honourable member.
So how much money has the government spent on their lawyers fighting the Human Rights Tribunal? If you don't want the...
The honourable minister.
I think the most important number, Mr. Speaker, would be that from $600 million that used to go to child and family, it's now $1.6 billion going to children, and we have no intention of fighting children in court. We want to get to the table and get them what they deserve.
Member.
I believe the minister in the House has to tell the truth. So either she's not telling the truth or her lawyers in federal court are not, because the lawyers in federal court has taken the position that this government, the Liberal government, has gone to quash a finding of systemic discrimination because they said there is no evidence with regard to adverse outcomes that flowed from being denied services. So the minister has told us that she knows again and again and again that services that have denied to children have hurt them, but her lawyers are saying the opposite. So who's not telling the truth here?
The honourable minister.
The approach of our government is to make sure that all children who were harmed by these terrible colonial policies will be compensated. But we also have learned from the Indian Residential School and 60 Scoop that the children who had greater harm or were in care longer, that these things need, and their voices, they want to be able to tell their stories. And like the class action on 1991 forward, we want to get to the table and get them what they deserve.
Member.
Well, actually, what the minister's lawyers are saying, which I want to let the people know, is completely at opposite what she's telling this House, and she's obliged to tell the truth in this House. They're saying that these children who are represented by the AFN, by Anishinaabe Nation, by First Nation Child and Caring Society do not warrant compensation because they have not been tested by the government to the, quote, precise nature and extent of harm suffered by each individual. So what is the minister going to do? Put 4-year-old children before her lawyers like they did to the St. Anne's residential school survivors? How are they going to test these children for the precise harms so that they don't have to pay?
Minister.
I think the member opposite understands that the class action that's now being certified on the 1991 post-60 scoop up till the present day it tends to be the way that we sort these things out in terms of what is the appropriate care for the amount of time people were harmed and the degree of the harm. This is very important that families have a voice, the children have a voice, and that there is some assessment of really fair and equitable treatment and compensation.
Member.
I'm quite shocked because her lawyers are in court saying there's no evidence any children were improperly taken. How can she stand up and misrepresent her lawyers? Then they said there's no reason for compensation. They have said that in the hearings. So to say now that we want to quash a legal finding that the tribunal spent 12 years adjudicating, and this minister's lawyers say there was no evidence to prove what was found, which they said was reckless, willful discrimination. How can the minister tell us that it's better to have that ruling thrown out so they can fight children in court and make them testify, each single one? That is what they want to do. How can she justify that?
Honourable Minister.
To say that I believe that in terms of the CHRT and the good work of Dr. Blackstock, that many good things have come out of this. This is Jordan's principle. 0 cases were settled. Now thousands of cases are settled all the time. This is very important. But in the case of appropriate compensation, I think that the appropriate place for that is with the class action, where there are representatives of the victims and and the survivors who they can determine what is fair. I don't think that there is a way for fair and equitable compensation to be done without the voices of the people who are harmed.
We're at about the 5.5-minute mark. The honourable member.
Well, I'm really glad she raised Jordan's principle. That brings us back maybe 4 non-compliance orders ago. And for the minister's lawyers to say there's no proof that any child was harmed is a falsehood, because the ruling on Jordan's principle was about the death of Jolyn Winter and Chantel Fox when her government decided that they were not going to bother to fund those children. And at the Human Rights Tribunal, they were forced to implement Jordan's principle, because every single time this minister's government came, they said we were in compliance, and children died. So children died because of that. So to say some good stuff's been done, now let's throw out the Human Rights Tribunal ruling. How can this minister claim that they went along with Jordan's principle when the filing showed they fought it at every step of the way and children died?
Minister.
I think that, Mr. Speaker, that the member opposite knows that we work very hard to be able to put in place Jordan's principle. At the beginning, the motion that we passed here in the House was only for children on reserve with multiple disabilities and where there was a squabble between the federal and the provincial government. We are now getting the kind of care that kids need on and off reserve, particularly when there's only one disability, a mental health problem or addiction problem, but also there doesn't have to be a squabble. We have moved way beyond what was passed in this House, and children are better for it.
The honourable order. The honourable member.
Children are certainly better for it. I agree with the minister. But children are better for it because Cindy Blackstock, the AFN, the Anishinaabe Nation fought them at the Human Rights Tribunal while they were refusing and children died. They have met the Jordan's principle because they have been forced to meet Jordan's principle. So I want to refer to the latest human rights ruling. It says there is sufficient evidence that Canada was aware of the discriminatory practices of its child welfare program, that they did this devoid of caution and without regard for the consequences on children and their families. That's the finding after 12 years, when this government spent $3 million trying to block them at every step of the way. So how is it that we should say, let's crush that ruling, let's throw that finding out, and then fight it out in court, and trust that this government actually cares about children, when the minister's lawyers say children haven't been harmed? Prove it. Bring in those individual children, the 4- and 5-year-olds, so we can test them. And that the tribunal found that this government has acted with devoid of caution over the lives of children. That is the finding of the Human Rights Tribunal. Is the Human Rights Tribunal lying? Or is it the government who's misled the people of Canada on this?
Honourable Minister.
I think the honourable member knows that our government has a very good track record on settling the childhood litigation. Anderson, 60 Scoop, day schools, we are doing what is right, and it becomes, and with the compliance orders, as I explained to the member, that from what was Jordan's principle and on a multiple disabilities only on reserve where there's a squabble, we've gone way beyond what that original vote in the House of Commons was that I voted for. So it is hugely important that we go forward, understanding we have to do the best possible thing for these children. The lawyers have agreed that we want to compensate. The Prime Minister wants to compensate, but we have to do it fairly in a fair and equitable way that also covers the children from 1991 to this day.
Honourable member, this will be the last question.
They want to quash the ruling, Speaker. That is what they are in federal court to say. If you look at the Human Rights Tribunal ruling, there's point after point after point about how to make compensation work, and this government says they will not compensate, they will litigate. That is the government's position. So I'm astounded that the minister's in here telling us that this government cares about the children when the finding says willful and reckless discrimination against children who died. The children who died had to be named. when they said there was no evidence unless we brought individual children's names forward. Well, individual children's names were brought forward because of their policies, and those children died, and children are continuing to die, and they will continue to die as long as this government refuses to do the basic funding, because our minister tells us the discrimination has ended. Well, that's not what the Human Rights Tribunal found, and that's not what any First Nation family in this country will believe.
Minister.
I think that First Nations, Inuit, and Métis across this country are very grateful for Bill C-92. We actually have to allow, and in terms of asserting jurisdiction, that they can assert the jurisdiction to look after their own families with the adequate funding to be able to do that. We know that in terms of how you determine fair and equitable funding, our government didn't think that we would be able to get that done throughout an election and by this week. So it is really important, and the January 29th date is coming up. But I am hearing from families they want this to be fair, and they feel that there has to be a negotiation at a table to actually determine what is fair.
Debate. The Honourable